Morning. Are you Deshaun? Is it Vital or Vital?
Vital.
Vital. And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does, Judge.
Mr. Vital, in cause number 25 DCCR 1107, you're charged with a first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Freely.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 1109, you're also charged with a first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead in that charge?
Guilty.
And are you pleading guilty freely and voluntarily? And again, because you did what they charged you with. In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 10-year deferred probation, that ISF would be ordered. So when is your 18th birthday?
April 8th.
Okay, so it'll be less than that at sentencing. So
Right.
we'll do upfront time until your birthday, and then you would go.
Right away, this hearing is about one thing: bond reduction. The defendant is facing an $800,000 bond on a murder charge, which is incredibly high but not unusual in serious felony cases. The defense wants it lowered so he could potentially get out while waiting for trial. But in hearings like this, the judge isn't just looking at the charge, they're judging risk, behavior, and credibility. And as you'll see, that's
to
where things
ISF. Is
start.
that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Vital is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. So are you at Minnie Rogers or at the jail?
Judge, can I address something?
Yeah.
Obviously, Mr. Vital has been in custody for several months. He's going to continue to be in custody for several more months. While he's in the Jefferson County Correctional, he's mentioned multiple times in reports, typically he's a victim of other people's behavior. There are a couple instances where he's doing things he
Yeah, I don't
shouldn't do,
see
but
many at all.
it's not the worst of the worst. It's not my concern. I just wanted to explain to him that it's important. And the last note I saw was that he'd been moved out of a dorm where he was being victimized
Yeah.
and bullied.
Yeah.
I want him to be successful. I want him to understand
I
that
do too.
those reports can change. What gets reported between now and sentencing can change what happens in this case.
Sure. Thank you, Mr. Nichols. And I was going to address that. And you may have heard out there already that incident reports at the jail don't go over very well with me. I do understand there's been some things going on that weren't your doing, and so you just keep doing what you need to do to keep your head down to make it until we get to sentencing so that you can be successful. You're doing the right thing. If we end up with some reports and you change your behavior, which I don't see any reason to, you've been doing pretty well. And it sounds like the jail has taken notice of what's going on and where you need to be. But just continue doing what you're doing so that when we get back here in a few weeks for sentencing, I don't have any issues, and Mr. Nichols doesn't have any issues to look at with regard to jail incident reports, okay? All right, you can go back with the bailiff.
Thank you, Judge.
This is a crucial moment. Once the defendant is sworn in under oath, every word becomes legally binding. If he lies here, that's perjury, a completely separate crime. But more importantly, judges pay very close attention to honesty during bond hearings. One contradiction, one exaggeration, and the judge may start questioning everything else the defendant says.
Thank you.
It's bad when I read the report and all the other.
Would y'all, I'm going to print one, if you'll print the other, please. It's MTRPs. Robert Joseph, if you'll print somebody print the second one, please. Give me just a second. Get these printed out. Look, I can probably get it before you with your computer.
Pulled it up now.
You got it?
Yes, ma'am.
Okay. All right, well, you're Robert Felix Jr., Joseph Jr., and will your client waive the formal reading of the motion in each case?
He will, Your Honor.
In cause number 21-38610, I have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the first-degree felony offense of manufacturing or delivering a controlled substance, and that was a 10-year term in prison that was probated for 10 years. Is that correct?
Now the judge is digging into behavior inside the jail, and this matters more than many people realize. Bond decisions often hinge on one question: can this person follow rules if released? If someone can't follow rules in a controlled jail environment, judges often assume the risk is even higher out in the community.
Correct? In cause number 21-38611, I also have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the third-degree felony offense of unlawful possession of a firearm by a felon, and that was also a 10-year sentence that was probated for 10 years. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of public intoxication October 3rd of 2025. And is that true or not true?
True.
Count 2 in each case alleges that you failed to maintain your financial obligation to the GPS device company, failed to charge that as well. And is that true or not true?
True.
And then count 3 in each case alleges that you're behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 in each case freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand?
This is the kind of exchange defense attorneys dread. The judge is confronting him with incident reports and threats toward officers, even if the case itself hasn't been proven yet. Behavior like this sends a powerful signal: lack of control and potential danger, and in bond hearings, perception of risk can be everything.
Understand, if I go along with this agreement today, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if I go along with this agreement, that this is a huge opportunity based on your history and what you're in here for?
Yes, ma'am.
Judge, may I provide
Sure.
the explanation?
Yes, ma'am.
to the court? I certainly agree with what the court just said. I know this defendant from his being here before. He's not somebody that needs to be in this courtroom. He's 18 hours shy of a college degree. He was a college football player. He got totally off track.
Yeah.
And has just, I've spoken with him in the back. I've spoken with his probation officer. She asked that the court consider this sanction and allow him to be released for the holidays, with the understanding that the pretty low offer that Mr. Rojas and I had discussed previously is now off the table, that he will be on zero tolerance if the court would allow, that he will have to continue to have that GPS on and show you that he can do what he's supposed to do with it. He was hemming and hawing back there about how much he spent on it, and I told him, in my opinion, he's going to have to prove to you that he can stay on that GPS and do what he's supposed to do and do what Ms. Bradley asked of him, what you asked of him. And if he does that, I'm willing to give him the opportunity, if you are, with the understanding that if he's back, I will ask for the full time.
So, and I recognize you as well, and I know you shouldn't be in here, and it looks like you were doing well for quite some time. And so I'm gonna do what everybody feels like you have the opportunity, your probation officer, the district attorney's office. Because of the nature of the offense and what was going on, at least for some amount of time, you're gonna have to wear the GPS monitoring device. And so I know it's not cheap. You're gonna have to get a job and figure it out. It's very important. It's charged at all times. It's paid for. I've gotta know where you are and that you're doing the right things.
Yes, ma'am.
If you do that for some amount of time correctly, it's always charged, it's paid for, you're up to date, then you can ask your probation officer to ask me if I'll let that go, and I probably will.
So I can ask you directly?
They send me, so I have a box in my office that I get a pile of stuff from probation every single day. Early terminations, requests for monitoring device to be, all of those things. But they're not going to send it over and ask me on your behalf if you have not done everything you're supposed to.
They told me I had to hire another lawyer.
Well, they can send it over. Now, if you want to, a lawyer could file a motion, they can send the request over for you. But, and I'll take a look at it and see what all's been going on and talk with your probation officer again about how long you've been on it and what's been going on. If there's any change, I'll let her know. But for now, based on the new allegation, you need to...
The prosecution brings in a powerful legal argument under the Texas Constitution. If someone commits a new felony while already out on bail for another felony, the court can actually hold them without bond at all. So suddenly the question isn't just whether the bond should be lowered, it's whether the defendant should have any bond whatsoever.
Get it, keep it, and then I'll reevaluate that, okay?
Yes, ma'am.
So this was a plea agreement, obviously, that I followed, and so you've waived any right to appeal. I handed you the trial court certification that shows that, all right? Good luck to you, sir. You can go back with the bailiff. Oh, and so, sorry, I feel like I skipped everything, actually. So the agreement was also for 60-day jail sanction, and that's with credit for time he's been sitting.
Yes, Judge.
And he has you've been in there?
Today is day 64.
Okay, so, state tenders number 1.
No objection.
It's admitted, any evidence that Mr. Joseph is not competent.
No, Your Honor.
All right, then I am going to, again, follow the agreement and continue you on probation, order that 60 days up front as but with credit for it as a sanction in both of your cases. And so you should be released today, it sounds like. Go straight to probation, get everything back in order, and then you'll be fine, okay? All right, good luck to you, sir.
Here comes the decision. After hearing about the violent charge, the jail incidents, and the criminal history, the judge weighs the key factors: public safety, credibility, and behavior while incarcerated.